Well, we are now joined by Advocate Koome Muketha. Thank you very much for finding time to come and be with us. Azimio la Umoja Kenya has given that ruling a thumbs up. And I want to hear what your reflections are first.
The biggest issue right now is that the ruling has come out. The Finance Act has been seen for the large parts that it's unconstitutional in some aspects. However, the biggest challenge right now is the issue of the stay, that the judgment has been declared unconstitutional, but there's a stay until 10th of January, which essentially means that the act is still in place as we are speaking right now.
But let me ask you, how is it? The court pronounces itself, that the levy is unconstitutional. So where is that latitude, even for 1 second or even for just a day, to then proceed and grant a stay order? Isn't that a bit schizophrenic? Is it,
The courts have been trying to balance out some of these public issues, because these are matters of very serious public interest that are underlying, that at the end of the day, Kenyans are losing a segment of their salary, despite the High Court having found the issue to be unconstitutional. But as we have seen in the past, for example, a few years ago, when the national land regulations were declared unconstitutional for lack of public participation, the court still gave the Ministry of Lands some time to rectify that. I think that from the reading of the judgment, that is essentially the same argument they are advancing, that when matters are of serious public interest, sometimes it's not enough to just strike them out without leaving some latitude for the government maybe to rectify that and craft a way forward in terms of how now they are going to proceed with this issue.
That sounds like a precedent.
Yes.
Okay. So let me ask you then, therefore, because given that the appeal mechanisms that are there in place, so in terms of timelines, what are we looking at once the 45 days elapses?
Yes. First of all, the Court of Appeal has been known to be a bit slower than the other courts in the past. However, in a matter of such serious public interest, they have to act fast. However, looking away the way this country sometimes works, because we have seen this issue drag its way through the courts since July, we are now towards the end of November. If the courts cannot get a judgment for us by at least mid-January or end of January, the Court of Appeal, then we end up now moving to the next phase of budget making with uncertainty about the previous Finance Act for the 2023-2024 financial year. And this, I think, will prove a lot of challenges for the budget, for the policy makers, the budget makers, Parliament and other entities who all rely on some legal certainty on the budget making process for them to move forward.
So that means they have to be done and dusted by when? Given that cycle of budget making.
I believe, considering we are headed towards the Christmas period, the court must be able to get all the written arguments in before they break for the Christmas period. Then we can have the oral arguments made in early January, before the stay period lapses, so that they can get a judgment in and around the time when maybe early January, around 10th, 11th, before 15th of January, when we can have now a bit of room for the court between the stay and the judgment, not to have too much uncertainty in that period.
So talk to us about a best or a worst case scenario, because we also have in the back end the housing program.
Yes.
Does it spell doom, for example, if it goes one way or the other?
First, the government, this is not the first time that this program has been brought up by the government. We saw it in the previous administration. It was challenged by the lawmakers, it was challenged by different policy makers, and it has cropped again in this administration. I believe these are from the way the administration has been going about it. It's a serious policy projection that they want to move. And as we had the president saying that they will want to go back, look at the judgment, look at what they can correct, and they will certainly reintroduce it in one way or the other before the next financial year begins. We are certainly going to see it back.
So the workers what would you say? Is it too early for workers to celebrate?
I believe it's too early for the workers to celebrate. I believe at this point we can, I would, from a legal perspective, I would advise maybe people to start planning with that aspect, with as a sort of a levy in mind, because it's very clear the court, even the aspect that the court found to be unconstitutional, are things that can be rectified, for example, by providing a legal framework which is what we've just heard the president say in his reaction. Yes.
So your crystal ball is telling you start preparing, have the tax in mind. What about those ones who are already planning around refunds?
I don't think the judgment from even the behavior we have seen from the courts. First of all, we got a temporary stay when Koome Muketha and company first approached the court. They were able to get a temporary stay, which was later lifted by the Court of Appeal. Today we have seen a declaration of unconstitutionality, then being stayed for quite a number of days. I believe it is a clear message to Kenyans that it's time to start preparing with that in mind. And maybe what you can move towards interrogating is now the legal framework that the government now comes up with, the laws that come up, the legislation that comes out of Parliament, and the policies that come out of the Ministry of Housing. That is what we should move towards now interrogating.
So yes. The probable next course of action for the state, as far as you're concerned, upon the elapse of 45 days is? I
believe we will see an appeal within the next week or two, a proper appeal being launched. We will see written arguments being presented in court. Yeah. And if the court moves fast, we can. I'm certain that the state will look to extend this period. If they see that they cannot get a judgment, that the Court of Appeal cannot render a judgment before 10th of January, we'll possibly see another application in court seeking to extend this period, maybe up to the end of January, to allow the court to look at the arguments and make a proper judgment.
Thank you so much, Koome Muketha, an advocate of the High Court, giving us his reaction to that ruling.